support the principles undergirding the Federal Religious Freedom Restoration Act, and have worked to balance religious liberty and state rights, civil rights legislation across the country. SB 129, as currently written, however, fails to achieve an adequate balance. Direly needed, yet modest protections have been secured in discrete municipalities in Georgia against LGBT discrimination in housing, public accommodations, and employment. My largest concern about this bill is that it will permit free exercise challenges to civil rights laws and ordinances. The public is told that this legislation will not undercut non-discrimination norms, and I have no reason to doubt the sincerity of Senator McCoon or others who make those assurances. But a number of grassroots supporters have explicitly stated that goal while claiming to have no invidious interests. In short, their definition of discrimination is fundamentally different than most Georgians. For some proponents, denying services, housing, or employment on the basis of, say, race or sex is indeed wrongful discrimination, but mistreating gays and lesbians in the public square is not. If there was any doubt to the veracity of that observation, I suggest that the intense opposition to any amendment that would remove civil rights laws from RFRA's application speaks for itself. I believe that non-discrimination claim or any challenge to non-discrimination laws under RFRA will not really are unlikely to succeed. But it is an open question whether the state courts of Georgia would agree, and specifically there's no guarantee that the state courts in Georgia would consider local government interests in enacting non-discrimination protections as satisfying the tests set forth in RFRA. Now, I have great faith in our judges in Georgia, but LGBT Southerners are understandably skeptical. We cannot take for granted that our state courts will always mete out justice in our favor, as the Alabama Supreme Court has recently reminded us. Even if the ultimate conclusion of RFRA litigation arising from LGBT civil rights enforcement is resolved in municipalities' favor, it will have been achieved at considerable taxpayer expense. In that vein, there is a real, non-hyperbolic danger that the threat of costly litigation alone may deter municipalities from expanding non-discrimination protections, and that alone is a risk we cannot take. SB 129 includes language that seeks to assuage these concerns in legislative findings. But as we all know, these are merely a gesture. It is a fundamental principle of statutory interpretation that legislative findings have no robust legal operation. The vagueness in that language is complicated further when read against Georgia law more broadly. Georgia is one of only 3 states that does not prohibit public or private employment discrimination on any basis, including race and sex. It is one of only 5 states without any public accommodations law. Given Georgia's thin statewide civil rights law, how courts might use SB 129's legislative findings is unclear. At a minimum, I suggest that the bill should be amended to exempt civil rights law. Texas is a great example, but there is a particular problem with Texas's language, and I would refer you to Missouri as a better example. Missouri's statute specifically takes into account the fact that many protections are in municipal law. My understanding from the top of my head, I don't have it in front of me, but Texas's civil rights exemption does not exempt local non-discrimination laws. So therefore, under Georgia, most folks it would render that civil rights exemption fairly meaningless if it only applied to state statute. We must not jeopardize civil rights law, discourage municipalities from expanding non-discrimination protections, or otherwise embolden anti-gay animus. I urge you to reconsider this legislation in its current form and find ways to work together to advance the civil rights of all Georgians. I'm happy to take your questions.